Well, hello, and thank you for joining me today for Avoiding Nursing Home Spend Down. My name is Lynn St. Louis, and I'm an estate planning and elder law attorney at ELG Estate Planning. And one of the things that we do here is not only prepare estate plans, but we help people protect their money from long-term care costs. In order to help you understand how we accomplish avoiding nursing home spend down, we're going to need to take some time and talk about what Medicaid's rules are. So I'm going to make this as simple as possible and not get too bogged down. But honestly, Medicaid is one of the most complicated areas of practice with all sorts of very Byzantine rules and some confusing rules. So I will do my best to make it understandable. Now, I said that we do estate planning here at ELG Estate Planning. Yes, we do. And part of having a good Medicaid plan is having the necessary tools in place, which are having a good estate plan. Today, we are not talking about what does a good estate plan look like. There are other talks where we do get into that in detail, but for today, we're going to assume you have a really good estate plan in place, one that allows you, if you're not able, somebody you designated to act on your behalf and do what they have to do to put a Medicaid asset preservation strategy in place. So, and I'll touch on that when it becomes important to talk about, well, why would a good durable power of attorney be important? It's important so that the Medicaid plan can be implemented. So, nursing home spend down. When we're talking about nursing home, we're talking about what's skilled nursing care. It is very expensive care. It can run $10, $12, $14,000 plus per month. That's a big number. And because of that, understandably, people are very concerned that if they or their spouse ever needs to go to a nursing home, it's going to wipe out everything they've worked so hard for. And it could, especially if you don't seek the services of an elder law attorney with expertise in Medicaid planning. At ELG Estate Planning, we have that expertise. We help clients with Medicaid asset preservation strategies, Medicaid applications. We have many such current matters going on all the time. Today's discussion is about Medicaid's rules in the state of Washington. So if you are viewing from a different state, keep in mind that you're going to need to be speaking to an elder law attorney in your state because every state has a different set of rules. Now, right behind me, I don't know if you can see that, we have a book on this, how to protect your assets. So that's one of the things that if you're interested in, you can reach out to us. Our phone number is 509-468-0551. Our website is elgestateplanning.org or elderlawgroupwa.org.com. I don't know if you can tell, but I'm struggling with a little bit of a cold, so I'll do my best. So we'll put that in the chat so it's clear where to reach out to us if you're interested in this Medicaid book. All right, so let's get into it. How do you protect your money from having to be spent down in the nursing home? Well, there's a few things that we need to understand. How do you pay for your nursing home care? You pay for it from your own income and from your savings, unless there are other sources available to you. For example, do you have long-term care insurance? If that's the case, that's going to be another payment source. Or do you have VA benefits, especially service-related benefits, such that you are that the VA will pay for your care? If so, that's another payment source. A lot of times people, well, let me talk about Washington. In Washington, we have a new program. It's an insurance-based program called the Washington CARES Act, and that is intended to get us in the right direction for how do we pay for our long-term care. But it's quite a minimal benefit at this time. You have to pay into the system for 10 years, and it just started. And you get about a $36,000 benefit. Remember what I said? It may be $13,000 a month in the nursing home. So the benefit doesn't even pay for 3 months. So it's not going to cover what needs to be covered. What does? Well, you might think, okay, well, Medicare will. And you would be in good company if you thought that Medicare is going to pay for your long-term care, but you would also be wrong. Medicare does not. It is to pay for your doctor, your hospital visits, etc., but does not pay for your long-term care. Yes, it can pay for up to 100 days in a skilled nursing rehab facility after a hospital stay, but it does not pay for the long-term care that goes on for months and for potentially years after that. So don't think Medicare is going to pay for your long-term care. It will not. So that's why most people spend down all their money and become impoverished. You don't have to do that. So I'm going to go over the rules about what Medicaid's resource limits are. Medicaid has rules that are different if you are married versus you are single. And if you are single, I have really bad news for you when it comes to Medicaid's rules. Indeed, it is an impoverishment program. That's not to say we can't help you from spending down all your money. We certainly can, but it's not as easy as if you were one of a married couple, because a married couple, Medicaid's rules are far different. So let's talk about what the resource standards are. When it comes to income, how much income can you have and qualify for Medicaid? And I have to tell you, income is rarely a disqualifier. If your income is $20,000 a month, you don't care about Medicaid. You can pay for your $14,000 a month nursing home, but that's a rare case when anybody has that high of income and they're looking at long-term care. So let's talk about what Medicaid's rules are in the state of Washington when it comes to income limits. When it comes to income, if you're in a nursing home, your income basically should be less or has to be less than what the private pay rate is. Okay? Private pay rate's $14,000. Your income's less than that, then you meet the income standard. Not a problem. Medicaid pays for care not only in a nursing home, but in less restrictive settings. For example, Medicaid will pay for care in your own home. Medicaid will pay for care in an adult family home and in an assisted living facility or a memory care facility. So those Medicaid programs in Washington state are typically under what we call the COPS program, Community Options Program Entry System. Nobody calls it that. We call it COPS. Under the COPS program, let's say you are going to an adult family home and your income, here's what the current standard is in 2024, your income cannot exceed per month $10,387. Okay? You qualify under the income level. Single or couple, you qualify. So that's really not a big barrier. If you are looking for to qualify under what's called the Community First Choice, which is another program, it's a really important program because it doesn't have a transfer penalty. We'll get into that. The income limit for you at a care facility is $2,829. Or if you get care in your home, it's $943. So it's a pretty low level. Why I'm even talking about Community First Choice or CFC program is because, remember, we're talking about how not to spend down all your money. The Community First Choice program does not have a transfer penalty. For the most part, Medicaid says, hey, if you've got so much money, you're giving it away, we're not going to provide benefits to you. Makes sense. It's called the 5-year look back rule. So we have to be very aware of, no, don't give away your assets unless you're doing so with a strategy, a plan in mind. But the Community First Choice program does not have that penalty period. So sometimes when we're working with clients and they want to, qualify for Medicaid, one of the first things we look at is what is your income? Because if their income is within those limits of $943 for care at home, $2,829 for care in a assisted living or adult family home, they'll qualify for benefits, even though perhaps they have $100 or $200 or more $1,000, which they wanted to go to their kids and not spend it all down. So they give it away, and they can do so because Medicaid under the CFC program will pay for their care. So that is a very exceptional program, and it's something that we as elder law attorneys doing Medicaid planning will always be looking for, depending on what the client situation is. So I kind of went down the rabbit hole a little bit, giving you more details about income and the CFC program. So let me back up a little bit. Let's talk about resources, because this is where Medicaid really gets tough. If you're a single person, you can have $2,000 in countable resources. That is an impoverishment standard. And that's why one of the reasons Medicaid is well known to be an impoverishment program. So what can you do? We'll talk about that. The good news is, though, that if you are a married couple and you're married and one of you needs care, you're both alive, one of you needs care, you can keep more than $2,000. The person, the spouse who is going on Medicaid, can only have $2,000. But how about the community spouse, the well spouse, the spouse that doesn't need care, and the spouse that needs to have money and assets available to them so that they can live their life and not become impoverished? Well, there is something, a policy that allows the community spouse to keep money. There's a policy against impoverishing the community spouse. So what we have, it's called a community spouse resource allowance. And in the state of Washington, our rule says that the community spouse can keep at a minimum $68,301, and at a maximum, what countable resources can they keep? $154,140. For many people, that's all they need is just Medicaid's community spousal resource allowance. For others, that still would require a spend down of money. We'll talk about how to avoid that. But what I want you to understand is, for couples, they can keep far more money than a single person can under Medicaid's rules in Washington state. Oh, I just talked about what are countable resources. What's a countable resource? Money in the bank, an IRA, a 401k, investment money. What's not a countable resource? A whole lot of things are not countable. And this is a great planning opportunity. So what's not countable? Your house is not a countable resource. So let's say you are a married couple. Never will your house be counted. Great news. Your house can be worth $400,000, $800,000, $1.2 million, whatever. Your house doesn't count against you. So for many people, their house is one of their largest assets. So that's really good news. You don't have to sell the house, spend down all that money. If you are a single person, I have more good news. You can keep your house too. When you keep your house, your house can be worth over $1 million. Current standard is $1,071,000 in what your equity can be in your house, and you can keep it, single person, and qualify for Medicaid if you're otherwise within the resource standard at $2,000, because your house doesn't count. It's not countable. Now, the bad news for a single person is that if they qualify for Medicaid and they keep their house, and their house is considered non-countable because the Medicaid client signed a form that says, I intend to return home, therefore it's a non-countable asset. When they die, if nothing else has been done to protect that asset, the state will have a lien against the asset. So one of the things that's really important for single people is work with an elder law attorney to see what can be done to avoid the state's lien on that house. So non-countable assets, your house, one car, all your personal property, all your stuff, a life insurance policy if the face value is $1,500 or less, some long-term care insurance policies, partnership policies they're called. Oh, a burial plan, an irrevocable burial plan, or a burial plot or irrevocable burial plan. That's pretty much covers it. What I'm saying is that when you're looking at what your situation is and you're thinking, oh, I need to sell my house, or you don't know what to do, keep in mind that Medicaid's rules are pretty complicated, and it could be that you qualify for Medicaid with what you have in assets right now. Qualifying for Medicaid is one thing, but keep in mind that it's also important to avoid the state getting whatever that you own, especially if you would like it to go to somebody other than the state. That's going to require you to work with an elder law attorney who understands Medicaid planning. All right, so if you have questions, especially as I'm talking about resources, I'm going to see if I can answer them as we go along. The question about right now that I'm looking at about Medicaid and resources, when do you or should you put your house in a trust? So I'm going to take that question now because I think it's really important that we answer that one. My discussion today is talking about people who need Medicaid during their lifetime, need long-term care during their lifetime. So let's start. I'll answer that question first by talking about a couple, then a single person. For a couple, if you have your house in a revocable living trust, then disregard what I just told you about it being a non-countable asset. It is countable. A revocable living trust changes the character of your house from being non-countable to countable. Does that make sense? No, it's completely form over substance, but that's Washington's rules. So if you have a revocable living trust, an RLT, and we're doing Medicaid planning for you, we're going to take the house out of the trust and put it in the name of the well spouse. We have to do that. It's the only way you can qualify for Medicaid. We do estate planning for couples through having wills with testamentary supplemental needs trusts. That is estate planning documents and a plan that takes effect after somebody has died. And we're not talking about that today. I just want to share enough with you to understand the difference that when we say have a will with a supplemental needs trust in it, so you protect your spouse when you're gone so that the assets of the deceased spouse will pay to that trust through your will, through the probate, and they'll be in the trust for the spouse who survives you, and Medicaid will never count them. It's a fantastic asset protection tool, the will with this trust. But that happens after death. And what we're talking about today is Medicaid planning before either of the spouses has passed on. When the question is about when do you put your house in a trust, there are so many different kinds of trust. I just described two. Revocable living trust, which is what we call a lifetime or an inter vivos trust. A testamentary trust, which is one through your will. There's also what are called irrevocable trusts. Trusts during your lifetime, for example, that you create to put your house in a trust so that that house is never subject to the state's lien. Now, and remember, the house is not countable, assuming it's not an irrevocable trust. We're talking about irrevocable. But sometimes people want to put their house in an irrevocable trust, and they want to do it 5 years before they ever anticipate needing care. And the reason that they do that is they want to make sure their house is protected. And we have done plans for single people who have a house. They want to make sure their house goes to their kid without the state getting any of it. And so they're 5 years plus in advance of needing any kind of long-term care. So we'll create an irrevocable trust. The problem with that is that they cannot be either a trustee, they can't be a beneficiary. In other words, if they want to live in their house, because maybe the kid is the beneficiary and maybe somebody else is the trustee. This person has given away their asset. They have to, for this kind of planning, they actually have to pay rent on their house. So sometimes that's not what people want to do. So sometimes it's good planning, sometimes it's absolutely not good planning. So when you're talking about a trust, the question needs to be, what kind of trust and where are you at in life? And does it make sense? And what are your priorities? But typically for Medicaid planning, typically we are not putting houses or other assets into an irrevocable trust. Let me back that up a little bit. Much more common with a use of an irrevocable trust, it's also called a Medicaid 5-year look-back trust, is that we will put the lake cabin in the trust or other legacy property in this irrevocable trust. Something that isn't the home you live in, but place that is really important to you that you would like to see continue on to the next generation and the next generation. If you do that in advance of 5 years, you can do that. You can put it into an irrevocable trust. There's lots of planning that we can do, and we can do planning 5 years in advance of needing care. We can do planning at the time of need. But obviously, some types of strategies are only available to us if they're done well in advance. For example, putting the lake property into an irrevocable trust, or it doesn't even need to be put in an irrevocable trust. It can just be gifted outright. That's another option too. All right. So what we've talked about so far is Medicaid's income rules and Medicaid's resource rules. And we've touched upon the fact that for most of Medicaid's programs, you cannot give away assets within 5 years of needing Medicaid, because if you do, Medicaid says, sorry, you don't get any benefits. One of the things that we look at when a person says, I need to qualify for Medicaid, is we look at what level of care they need. Is it going to be in a skilled nursing home? Is it going to be under the COPES program? Or do they qualify for the CFC program? What can we do to use their money smartly until Medicaid's going to be available? Nursing homes, for the most part, do not have a private pay requirement. There definitely are some that do, but most nursing homes don't require their patients to privately pay for 2 or 3 years. Why? Because nobody could. It's just too much money. So most nursing homes will accept Medicaid as the payment source immediately. Contrast that to adult family homes and assisted living and facilities and memory care facilities, the majority of which will have a 2, if not a 3-year private pay requirement. Why that's important is that you don't want to wait till the last minute to see your elder law attorney, because you don't want to go through the 2 to 3 year private pay and spend down all your money and then go see an elder law attorney to say, how can I preserve assets? You want to do that at the start, because at the start, then we can put a plan in place to say, all right, there are ways to satisfy the private pay requirement that won't necessarily require you to spend down your money. And then Medicaid will be available to you when the facility will accept it. So keep in mind that when it comes to care at an adult family home or an assisted living facility, even if the facility says we've got a 2 or 3 year private pay, see an elder law attorney so that we can put a strategy in place to preserve as many assets as possible so that you don't have to spend down all your money. So let's talk about ways. Let me give you first an example of how the penalty period works. Remember, we have the 5-year look back, and the 5-year look back says you give away assets, you're not going to get any benefits. Well, it's not forever. It's not for 5 years or for the rest of your life. It depends on the size of the gift. So currently in the state of Washington, the state tells us that our monthly average statewide private nursing facility rate is $11,899. That is the figure the state uses as a divisor. So if you give away $11,899, you have a 1 month period where Medicaid won't pay benefits, but after that, they will. So it's just a multiplication. I'm going to round it up to 12,000 to make it easier for math. If you give away 100, I need to move more. My lights went out. If you give away $120,000, then you will have a 10-month private or period of ineligibility. So again, it's just a math thing. And we use this penalty divisor calculation to help our clients, and I'll show you how we do that in a few moments. So that's how we figure out what the penalty period will be. The penalty period is not implemented until the person has filed a Medicaid application, they need care, and they are otherwise eligible. So for a single person, what does that mean? It means they only have $2,000 in countable assets. So the timing of giving away assets and implementing the strategy is critically important, because you just can't give away money and think that the penalty period is running. It is not. Those were the old days. That's not what our rules are today. A couple more things before I get into various strategies that can be used by a couple or by a single person. I want to let you know that there are some transfers that result in no penalty, no period of ineligibility. So, for example, let's say you're a single person, you have a son who is on SSDI, which is a disability payment being received because maybe you have a back injury. Well, Medicaid says you can give away all your countable assets to him and there's no penalty. Great. You just preserved all your assets. Now, if he's not your only beneficiary, then that makes it a little bit more complicated because he can't just thereafter go give half of it to his sister. There's got to be some period of time that passes, etc. And so you need an attorney to advise you on that. But that's just like one simple example. Other examples are, let's say you have a child who is actually on needs-based disability benefits. Let's say they're on SSI, they're a special needs child. You can create a trust for your child, put all your assets into that, meet Medicaid's requirements that say that this trust must be actuarially sound and pay out over the lifetime of your special needs child. Make sure it's a discretionary trust so that it meets the requirements of the government benefit rules. And you can give all your assets to benefit your child in this trust. So that is another option that's available. Other transfers that don't cause any period of ineligibility would be, let's say your child cared for you in your home for 2 years, because most people don't want to go to a facility. Most people want to stay at home, and oftentimes families help each other out. And the child is living with you in your home, providing care, and without this care, you wouldn't be able to live there on your own. So if that's the case, and if it's documented that the care was appropriate, you needed the care, and then you move from there to Medicaid without any interruption, in other words, with no private pay period, then you can transfer your house to your child, the caregiver child exemption, with no transfer penalty, no period of ineligibility. So that's another option. So what I'm saying is that Medicaid has these rules that says, no, you can't do this. And then there's exceptions. Well, yes, you can if this is a situation, if that is the situation. And so sometimes when we meet with clients, it's not a complicated plan. We find out that they have a son on SSDI and they're the only child. So it's an easy Medicaid plan. Other plans are not so easy, but it's important that when you're thinking about you or somebody you know or a loved one, they need long-term care, trying to figure out how Medicaid pays, You can watch all of these YouTube videos, read all of the books, do all of the research, and I can tell you with confidence that you will not have the right Medicaid plan. I'm sorry. You've got to be an elder law attorney with Medicaid expertise who can create the plan. Let me give you an example of something here. Remember when we were talking about resources, sometimes the resource level that people have, maybe it's a married couple and they're in a skilled nursing facility and they qualify for Medicaid. The husband qualifies for Medicaid and the nursing home facility says, you qualify. We understand the rules enough to know what your resources are. Let's just file the Medicaid application for you. You don't have to pay the lawyer for that. We can do it for you. And they do. And congratulations, the husband is on Medicaid and everything looks great. But what isn't so great is because there wasn't an attorney involved, when the husband dies, there were assets that remained in his name. For example, the house was never transferred out of his name. It's in his name and the wife's name. And when he dies, the state has a lien on that house because that's an asset in his estate. Had they gone to an attorney, the attorney never would have let that happen. Transferred the house to the well spouse. The nursing home's not going to do that. They're not lawyers. They were trying to be helpful. And maybe they didn't even realize what they did was that they subjected this house to the state's lien so that the house will be lost upon the death of the second spouse. Terrible outcome. Why? Because the people didn't know any better. And when I give you examples, I'm often giving you real life examples of situations I have seen. So it's really important that you see an attorney that knows Medicaid planning very well. All right, so let's move on. Because I promised you I would be talking about how you could avoid nursing home spend down. So in this case, let's imagine that none of those exceptions to the transfer penalty worked. None of that works. So we're going to take a couple, because remember I said couples have a much better set of rules that we're working with because the state allows them to keep way more money. And in addition, the state allows what is called a Medicaid compliant annuity. It's a single premium immediate annuity, and if it meets the requirements of what the state says it has to look like, it is an excellent planning tool. So we're going to talk about a couple who one of the spouses needs to go into the skilled nursing facility. And let me see, how much do they have in assets? For those of you who are listening, we are going to send some information for you. But rather than me getting bogged down in all those details, I'm just going to do something here that's a little bit easier to follow. So let's say we have a couple. We're going to call them Betty and Fred. And let's say Betty and Fred, you know how housing prices are. Their house now is worth $600,000. And obviously, I'm coming to you from Eastern Washington, because if I said it with that emphasis in King County, you'd be rolling your eyes. But so $600,000 house. They also have $400,000 in other assets. Their checking, their savings, their investment accounts, be it in an IRA or not in an IRA. They've got $400,000 liquid assets. So Betty and Fred have $1 million. Do you think they qualify for Medicaid? Well, not quite, but we'll get them there. Remember, the house doesn't count. So that $600,000, we take it off the table. Now we're talking about $400,000. Fred's going to be moving to a skilled nursing facility. In a skilled nursing facility, the amount of money the couple can keep, he can keep $2,000. Betty can keep $154,140. So I'm going to kind of be rounding it down a little bit to $150 for ease of calculation. All right, so I said that they had $400,000 in investment accounts and such. Medicaid's rule said they can only have $150. That tells me we've got what? $250,000 too much? And they don't want to spend down on anything. He's going into skilled nursing. He's going to go on Medicaid right away. Their house is fine. Their car is fine. They don't need to spend up and get a new car. They just want to keep all their money. And they've got 400,000, and Betty's going to need that money. So what are we going to do? Are we going to spend down to 150,000? Well, I think you know the answer to that. No, we're not. What are we going to do with that extra $250,000? We take that 250,000, and maybe somebody can put it in the chat. What's 250,000 divided by 60? Because that's the number of what the monthly income is going to be. So we take the extra 250,000. Betty buys a Medicaid compliant annuity. What that means is she takes this extra money, buys an annuity that Medicaid says is compliant with their rules, which means it will be a 60-month annuity. It will be an annuity that is non-assignable, irrevocable, and if Betty dies before the term of the annuity, then the state of Washington is the next recipient of what? The monthly amount that this annuity will pay is $4,166. How did we get there? Thank you for the math that's in the chat there. Is we took 250,000, the too much money, we divided it by the term of the annuity, 60 months. And from that, we calculate that Betty will get back nearly $4,200 a month, month after month after month after month. Because once Fred is on Medicaid, Betty, can continue to increase what her assets are. In other words, even though at the time of the application, she could only have 150,000 in the bank, plus this annuity. And why she can have this annuity is this annuity does not count. It's non-countable. So you take countable money, put it into a non-countable annuity, qualify Fred for Medicaid, and then Betty gets to get all of her money back month after month after month till it comes back to her. So she did not have to spend down anything at all for Fred to go on Medicaid, have the state pay for his care. And when Fred's on Medicaid, how is his care paid for? First, it's paid for from his income, and then the state pays the rest. Betty's income does not pay at all for Fred's care. That's Medicaid's rules. So that's a very, very simple example of how we can have this married couple keep all of their money and qualify the ill spouse for Medicaid. The great planning tool that we have in order to accomplish that is that Medicaid compliant annuity. And this is just one example. I tried to make it really simple. I would comment that if you have an annuity, like many people do for guaranteed income, you do not have a Medicaid compliant annuity. What financial person would ever sell you an annuity that says the state of Washington is the next recipient after the spouse? It doesn't happen. I mean, that doesn't make any sense. So the Medicaid compliant annuity is one that is purchased at time of need and complies with all the state's requirements. And so let's say Betty survives the 5 years. She can sell the money back. Let's say Betty dies during the term of the annuity. Then the state is going to get the money back as measured by how much in benefits they had paid to Fred as of the date of Betty's death. And if they get fully paid back, because it's a measuring thing, they don't all get the whole rest of it, no matter what his, how long he lives. They measure what's the amount of their lien as the time of her death, even though Fred's still in care for the next 5 years. Then the children do have an opportunity potentially to be recipients of that asset, of that annuity. So that's how we can protect all of the money for a couple when the couple is alive. Now, I had earlier mentioned, I'm not going to talk a whole lot about estate planning, but I am going to say that if Fred lacked capacity, we might be facing a problem with doing that fairly simple plan I just described. The reason is that we need to take the house and we need to put it in his name, and from his name to Betty's name. Do we have a durable power of attorney that allows us to do that? Do we have a durable power of attorney that allows us to do potentially other things for Medicaid planning? Maybe it's not just transfer all assets to the spouse. It could be, but it could be transfer assets, to a trust, for example. Maybe this couple didn't see an estate planning and elder law attorney before Fred got sick and needed to go to the nursing home. So they have these standard traditional estate planning documents, not one that an estate planning and elder law attorney would do like we would do. So maybe they have a community property agreement that says, hey, on my death, everything goes to my spouse, and it's an irrevocable agreement. We don't want to see that kind of community property agreement. We want a separate property agreement that says Fred owns nothing, Betty owns everything. So Betty needs to revoke the community property agreement and on her behalf and on Fred's, sign a new agreement called separate property agreement. But we might not be able to do that because Fred's durable power of attorney is inadequate for the type of planning that I just described. That is not uncommon for people who have not seen an elder law attorney. Keep in mind, when you go to an elder law attorney for your estate planning, we're looking at where your life is at the time you're meeting with us, but we're also thinking through all of these possibilities and what ifs. All these things happen throughout the rest of your life and then following your death. So we're not just doing, oh, this is a great estate plan for where you are right now. We're thinking, what might you need for the future? And we incorporate that into the estate plans that we prepare. And a traditional estate planning attorney will not do that. Why? Because they simply don't know the types of things that we've been just talking about, because they don't do Medicaid planning. All right, so let's see. I think we have time to talk about what can we do for a single person. And I'm always apologizing to the single person because we don't have that great plan that we have for a couple, because we can't transfer assets to anybody unless it's within the exceptions to the rule, like a disabled son or a trust for a disabled person or somebody. But I am going to give you some hope. One of the best things that we can do is we can use the house to preserve assets. So let me give you some figures and some numbers here. Let's say the single person owns a home. It's worth $300,000. Let's say their income is $3,000 a month, and they're at an adult family home that costs $5,000 a month. That's kind of low. Let's say $6,000 a month. So they're short $3,000 a month every month. And they can clearly see that they're going to run out of money, and then they're going to have to sell their house, etc. And there's going to be nothing left. And that's not the outcome that they had hoped for in their life. So what can we do? Recall that I talked about adult family homes and assisted living, memory care. They have private pay requirements before they'll even accept Medicaid. So likely what we'll do is, in this case, she's short $3,000 a month. That's $36,000 a year. So she's going to have to use her money to get through the private pay period. It's not a Medicaid issue. It's what will the facility accept. So over the course of 2 years, she pays from her income and her savings her 2-year private pay. Now they'll accept Medicaid. 2 years is gone. What are we going to do next? Well, she spent $72,000 out of her $100,000. So she's got $28,000 too much. What can she do? Well, she doesn't drive, but if we want to get her on Medicaid, we might just have her buy a new car. If she buys a new car in her name, she can give that car away to her daughter, for example, no penalty after she's on Medicaid. So we easily get her spent down to 2,000. All right, she's on Medicaid, but remember I said her house is going to be subject to the state's lien? What are we going to do about the house? We kept the house as a non-countable asset because we signed an intent to return home, but frankly, she's not going to return home. So we're going to sell the house. And when we sell the house, and let's just say it sells for, $300,000. That's way more than 2,000. She's going to be kicked off of Medicaid. So we're going to have her sell the house, and we're going to have her gift the proceeds of the house to her daughter, for example. So if we have her gift the proceeds to her daughter, let's say we have her gift $250,000 and have her keep 50,000. What happens? Well, if you gift $250,000, I'm going to need some help on this because my calculator's not working. What's $250,000 divided by 12,000? It's going to be about a 13-month period of ineligibility. During that time, what does she do? She's going to use some of the money that she kept. She kept $50,000. That will get her through that 12-month, 13-month period of ineligibility to cover her cost of care during that time. And then she'll go back on Medicaid. So during that 20 months, she uses the amount of money she retained. We only had her keep $50,000. So in this case, I'd have her keep more than that, maybe $60,000. Have her gift $240,000. She gets through this period of ineligibility, and then she goes back on Medicaid. She stays at the same care facility. Nothing changes. She's just, Medicaid's not paying, and she's using the $60,000 she kept. But what the end result is that $240,000, my recalculated figure, that she gave away, it's preserved for her beneficiaries. The car cost $28,000. It's preserved. So she's kept $268,000, not herself, but for those people that her loved ones, she wanted to receive that, and didn't spend down everything. And the reason that she's able to do that is because she's working with an elder law attorney who understands what Medicaid's rules are and fundamentally understands that care comes first. We never do anything that jeopardizes the care. And then after that flows the Medicaid plan. So there is a lot that can be done for a single person, and especially for a married couple, to keep assets. Married couples more likely to keep nearly all. Singles, at least a large majority of their assets, and not have everything spent down before Medicaid will cover the cost of care. So thank you for taking the time today to learn a little bit more about Medicaid long-term care benefits, Medicaid asset preservation strategies. That is one of the niche practices we have here at ELG Estate Planning. We have an office in Spokane and in Tri-Cities and in Seattle. So we'd be happy to talk with you further. If you or a loved one has any more questions about what can you do to protect assets in the case of long-term care costs. So appreciate you spending the time with me today. Thank you. And if you look in the chat, you'll see that we've got a YouTube channel for Elder Law Group, PLLC, and we've got our phone number there, which is 509-468-0551, elgwa.com, or just go to info@elgwa.com to get more information. My name is Lynn St. Louis. Thanks so much for spending the time with me today. Appreciate it. Take care.